to talk about these documents.
Jonathan Lee Riches, aka JLR, plaintiff v. Jason Smith, aka Rockalot, aka Unirock Live. So type defamation per se, libel, slander, tortious interference with business relationships, intentional infliction of emotional distress.
I'm assuming he has a lawyer if he filed. He doesn't have any legal standing by order of a federal judge to be filing these lawsuits in pro per. And like you telling me, and you're going on and on and on. This is like a brief. Shit, even a trial brief now in courts and civil courts and huge cases that I have. If it's a dispositive motion, it's longer, but they don't like this complaint should be defamation with this kind of nonsense. The complaint and a tortious interference claim, it should be five pages, maybe 6.
Pursuant to the federal rules of criminal procedure, that the defendant be sentenced to a 5-year term of probation with the special conditions of probation in addition to the other conditions of probation, that the defendant shall not file or attempt to file in any local, state, federal, or foreign court.
Wow.
Let's go down here. Any complaint or other legal document or pleading in a name other than his own, whether it be in the name of a true or fictitious individual, or may only file a complaint or other legal document or pleading in his own name if the case of action is genuine, meritorious, and well-founded. In fact, the law is not frivolous, specious, fraudulent, and or vexatious. The filing of a complaint, legal document, or pleading in violation of the special condition of probation shall result in a mandatory term of incarceration, which linked to be decided by the court. The government is free to ask the court to impose any of the terms of probation, including community service or a fine.
Lawyer perspective. If you're a lawyer, yes, you obviously have to know, down to the nitty-gritty of all the laws in each state. I was listening to these morons go on and on and on when there's a very simple answer. Okay. In order to sue somebody for defamatory reasons, two things have to happen. One, you either have to say the worst possible scenario and the worst defamatory thing that you could possibly say to somebody, or there has to be money lost. And when I say that it has to be so unbelievable, I can't even think of an example that would be so crazy that Donald Trump could sue for defamation if I said Donald Trump gave me herpes. As far as him filing a bogus lawsuit, this isn't a bogus lawsuit. His lawsuit is fine, but it's lies. And the reason why I say it's lies, I'm going to show you in a moment. JLR has had 0 loss because of Unicock's lies. 0. He's actually grown, not lost. Therefore, there's no defamatory nature.
Defamation per se.
Defamation per se is a defamatory statement made about the plaintiff where damages are implied as a matter of law. Usually the statement will be about the plaintiff, saying that the plaintiff is a criminal, suffers from a loathsome disease, engages in unfair business practices, or is some sort of a sexual misfeasance or malfeasance. In these types of situations, the law implies damages.
Just because someone lied on me makes them morally corrupt, but it doesn't make defamation. And again, is it a defamatory statement? Absolutely. Is it even a statement with is it a statement of malice? Absolutely. But did it do any malice? That answer is no.
What normally would be the most difficult part of a defamation case, which is damages, is now implied as a matter of law, and it becomes a presumption of negligent defamation. So the person who said one of those 4 negative things would be implied to cause damages against the plaintiff.
What do you get when you guzzle down lies? You'll get a cease and desist.